All right, welcome to our final panel. This is what I think of as the Are We All Doomed panel. Lots of changes in prosecution, lots of changes in litigation. What we want to talk about here are how that's actually affecting behavior on the ground. Are people doing things differently in the prosecution space? Are they doing things differently in the litigation space? Are they moving away from patents altogether? And if so, to what? And we have a great panel here to discuss this issue, starting with Ken Correa from Samsung Electronics, who's a senior vice president there and the head of United States intellectual property for Samsung. Jim Pooley, formerly deputy head of the World Intellectual Property Organization, now returned to the Bay Area, where he is a lawyer at Orrick, Herrington, and Sutcliffe, and perhaps the foremost expert in the country on trade secret law. And Lee Van Pelt, named partner at Van Pelt, Yee & James, doing patent prosecution and some other fun things. Why don't I start with you, Lee? We've talked a fair bit about kind of changes in prosecution. We've talked about 101. We've talked about changes in the board and the existence of IPRs. Are you changing the way you approach patent prosecution? Are you changing, are your clients changing whether or not they want to get patents and under what circumstances?
Sure. I think things have changed a lot. It depends on the area of law. If you get a call from somebody who wants to patent a business method, you probably really rather they hadn't called you. You're going to spend a half hour to an hour, probably pro bono work, sort of trying to talk them out of it. I think the odds have gone precipitously down, and I think that there are probably irresponsible practitioners out there who say, let's do it, but I think that's bad advice. And I think most of my colleagues at other firms would agree. If I have a colleague at another firm who's bothered me and I want to irritate them, I would try to refer them somebody with a business method patent. I think that's changed. I think in the more technical areas, computer security, things like that, if you can state a technical problem and a technical solution with some specificity that people are patenting that, I think that's still worth patenting. I think you can certainly make the argument in the patent office under Alice that you have something more than an abstract idea. It's a little more of a roll of the dice in the court. I love your writing, Mark. You talk about the pendulum. I think people are sort of anticipating the pendulum swinging back a little bit because there are certainly, it seems like there's some excesses right now. The other area I'd say there's quite a bit of change in that maybe, and I'm interested in your paper, sort of the patent market. The aggressiveness with which you hear from people trying to sell patents now. It's ramped up. And I know, so there's some of the information in your paper that they say the market, they've sold more than ever before. I also recall in 2009, a realtor telling me that things were great. I think you may see a little of that. These are private companies for the most part. You have to take what they're saying about the market with a grain of salt. There's a very large company that sells a lot of its patents that it doesn't want. I can tell you, I heard more aggressively and more often from those guys than I've ever heard from them, trying to sell stuff, trying to sell springing licenses to stuff they might sell to trolls. It sort of seemed like the atmosphere a little bit in the movie Glengarry Glen Ross to me, which Alec Baldwin, before he started impersonating Trump, was in that movie, and it sort of reminded me of the sales contest. First prize is a Cadillac, second prize is a set of steak knives, third prize is you're fired. And it seemed like there was that kind of level of pressure going on. And so I think that market is changing. And my clients, it's easier to talk them out of buying patents that I think are suspect. You know, there's less pressure. They're more inclined to saying, well, we'll take the risk, and if they're asserted against us, we'll fight it. And I think that's more often the right answer than it would have been 5 or 10 years ago.
Does that translate into changes in prosecution? I mean, if there are more sellers and fewer buyers in the patent market, what about clients who are coming to protect their own inventions? Are they not showing up as often? Are they saying, well, we're going to pick fewer patents? Or are they still prosecuting as they were before?
I think they're applying a higher standard to what they will patent. And I think that you're no longer looking so much at, well, we kind of can vaguely understand a problem. Let's sort of try to write a vague patent on any solution to that problem. I think there's a recognition that that's a bad idea and that's not likely to pan out. I think there's a higher standard that you need to have a technical solution to a technical problem, and I think that has changed.
And how do you do that? I mean, I know. So you said earlier, right? Well, if I've got sort of real technology in the software area, probably we're going to be able to get it through past analysis rejection. Is that a change in the way you're writing claims? Is it a situation where those patents are the same as they were before? Or are you shifting to means plus function claims? Are you writing narrower claims? Are you writing the spec with more detail associated with it?
Well, Mark, I'm surprised that you'd asked me that question because, I mean, Alice states that it's not to depend on the skill of the draftsman. so obviously how you write the claim really shouldn't matter, but it sort of does. And I think it's more a matter of putting in being less aggressive, putting in more specific steps in your claim, and also in the way it sort of changed a little bit the way you'd write your specification, your background, because you want to sort of use that as a forum to establish that you've got a technical problem. It's a specific problem. It's not just in the abstract trying to make stuff better, which is, I think, would have been the conventional wisdom on the right way to write a background 10 years ago. I think you now try to start selling the fact that you've got something that's not abstract, that is specific. And I think your claims will be, I think they really reflect that in being more specific and not trying to claim just a general, not trying to claim the outline, what I call Justice Breyer's outline. Measure something and act accordingly. If your claim, there's still danger that a court will boil it down to that. And by the way, most inventions, well, I'd say probably 80% of the inventions I've seen as an electrical engineer and a physicist kind of boil down to feedback, because feedback is a really important engineering principle. But it used to be you might write your claim to where it would be kind of clear that that's what it boiled down to, and I don't think you want to write it that way. You want to be more specific about how you do the feedback, if that's what your invention really reduces to.
And so that ought to, I think, have sort of implications for litigation, for IPR, sort of down the line as that new generation of patents comes through, right? So we got a bunch of patents written when the order of the day was let's be as unclear and broad as possible, and then we can sweep in everything. A lot of those patents, especially in software, have not fared so well under Alice. But I take it that if what we're talking about is a kind of somewhat narrower and more technologically specific set of patents, those are more likely to survive not just Alice, but probably also an IPR challenge, of a regular validity challenge. On the other hand, they may be harder to assert against infringers because it might be easier to design around them.
Sure. You have this interplay between breadth and validity, which has always been there. But I think that the wise prosecutor now is sort of, I like to say back in the 90s, you probably didn't want to, it was a mistake to come to me to write your patent because I was too conservative. I didn't really imagine that you could get away with what people got away with back then. So, you probably could have got a better job by someone who didn't think about it as carefully. But I think now you have to think about it carefully, and you have to identify, well, what is something that's going to be specific yet necessary? And that really is, when I talk to clients about what you want to find in a patent, it's you want to find something that's specific, so it's valid, but necessary so that it's likely to be infringed.
Other thoughts?
On the
Prosecution.
original question?
Yeah.
Well, first of all, my apologies about my voice. I just got back from Europe last night and caught something bad. But
Good to be sitting next to you, Jim.
yeah, move a little bit farther away. We know that there has been something really profound happen when Benoit Battistelli, the head of the European Patent Office, travels all the way to New York, as he did last month, to the IPO meeting to announce to everyone present that they should all come to Europe to file their software patents, because that's where they would get taken care of. And so maybe that's overstating it, but it is a competitive signal. And what I've been hearing in talking to the people inside companies that I hang out with and address general issues of IP strategy and management is that they are indeed taking a closer look at certainly issues like maintenance fees, but also the strategy at the front end. And this is, of course, not in all technologies, because we all know in certain technologies it's imperative to patent. But they are taking a closer look at the front end about whether they are going to publish, whether they're going to hold something as a trade secret, and that's where I often get into the conversation with them. And well, all I can say is that while in the past, these kinds of conversations have been fairly abstract, if I can use that word. Now, it's clear to me that they're quite serious about it, and there has been a shift in the way that they're going about engaging with the other members of their team to look at where they put their resources in addressing asset protection. So, again, anecdotal, but it feels very consistent with a real shift, that at least something that's happened over 5 to 10 years.
Ken, what's your perspective as somebody who manages IP portfolio?
Well, actually, I don't. But my perspective on that is, I'm an in-house counsel of a company who gets sued a lot, so I probably have a little bit different perspective. And the way I look at it is that the patent system exists for a reason. It exists for innovation. So you give inventor a right of monopoly over his or her invention for a limited period of time for disclosing the innovation that he or she came up with. So so the reward has to match the contribution. And I think up to this point, there has been somewhat of disconnect between the reward and the actual innovation. Why is that someone gets to have a monopoly right over a essentially idea rather than the specific implementation that he or she came up with? And I think Alice is really addressing that point that, look, it's great they come with invention, but monopoly right you're going to be given over that invention is going to be fairly close to the actual implementation you come up with. And so that's maybe that's more of a defense perspective, but your patent right should reflect what you have contributed to the innovation rather than some sort of windfall.
That sounds reasonable to me. And
Seems like 112 would be a better way to address that than 101, though. As you pointed out, I think more.
Next frontier.
Well, yeah, I mean, I think 101 is interesting, right? Because it bugs me as a law professor because it is conceptually inelegant. I don't think there's actually any underlying logic that draws the distinctions between what's patentable and what's not patentable in any meaningful way. And so it's really hard to look at the the law and say, oh yeah, okay, I know what claims are going to be patentable and what's not going to be patentable. That said, my sense since Alice, and especially as we've started to see some kind of cases going both directions in the Federal Circuit, is that in the software and business methods world, the courts are probably getting it right most of the time, in the sense that the patents that have died have mostly deserved to die, and the patents that have survived have seemed like they had more of a real technology associated with them. That doesn't mean that they're always going to get it right, because I don't think there's an underlying logic there that's more than, does this look technological to me? But maybe we're kind of muddling through.
Yeah, but doesn't that beg the question that Lee made, that, I mean, if someone were to drop down here from Mars and was introduced to our patent system and said, well, look, we need to make a decision about whether or not the thing that we're talking about should be examined at all. And the man from Mars would probably say, well, I also see in your patent statute a section that requires that you describe what you're talking about. Shouldn't we go there first to find out what it is before we launch into a discussion of whether or not it should be admitted into the process of patenting? And that, we are where we are, but I think the Supreme Court took a fundamentally wrong turn in Bilski, and we're stuck with it ever since.
So one of the interesting practical differences, and this may actually distinguish prosecution from litigation in this regard, right? So in prosecution, presumably the cost associated with a 101 rejection and the cost associated with a 112 rejection aren't all that different. But one of the effects of 101 in the litigation context has been that because we treat it as a pure question of law, courts have been willing to resolve it much earlier in the litigation process, to grant motions to dismiss, for instance, on 101 grounds. And that would be harder to do, I think, under 112, right?
Yeah. I think when you get the, motion to dismiss for 101, you're getting some sort of arbitrary and really capricious results. And another difference in the Patent Office and the courts is the Patent Office, you really have one decider of fact. And although there is variance amongst examiners, especially with the great job Michelle Lee's doing in the Patent Office, there's a tighter distribution. We have this sort of unseemly thing in the courts that it really depends a lot on which judge you get and which panel you get in the Federal Circuit, how you're going to fare, and that's unfortunate. You also get, you mentioned the software area. I think you have to sort of think how this has sort of been sloppily applied over in the biotech, which is not my area of practice. But I think, if you look at a case like the Sequenom case, there's the case of, the baby being thrown out with the bathwater, I guess literally, because, the idea that you can go from a test that is much more likely to kill the fetus to a test that the fetus is going to survive, that sounds not abstract to me. And I think that you have really 101 being misapplied in that area.
Whether or not I want to defend 101 in software, and I do think that sort of, while I don't like it legally, the effects have actually not been all that bad, because this have been a cheaper way to get rid of some bad patents. Much harder to defend in the medical diagnostics area. So is it affecting investment? So we started with Lee talking about kind of how you decide, how do you advise somebody, do I file a patent application? And the answer in business methods was probably no. What would the answer be in medical diagnostics? I realize it's not really your field. Is that?
I think it does affect. I mean, for one thing, it makes coming to Jim for trade secret and the feasibility of trade secret much more of a factor for a lot of companies. Whether that's an option for them, I think really matters.
Yeah. Well, and right, and then that's harder in the medical area too, right? I mean, it's harder to get. I mean, I think there are areas in which you can piggyback trade secrecy a little bit on the knowledge that you've got. So Myriad, for instance, once its cDNA patents are invalidated, still gets some benefit out of having a large database of information as to
Sure.
what other factors go into susceptibility to breast cancer. Much harder if you're going to have to submit something to the FDA to say, I'm going to hold it a trade secret, right?
Yeah.
Ken, are you, is Samsung behaving differently? Are you filing fewer patent applications? Are you pulling back on innovation and research and development investment?
Well, so I'm not sure I can answer that question directly, but yeah, I mean, the way I look at it is this. I mean, I think we're getting to this point is that the way companies behave will very much depend on which industries you're in. Obviously, if you're in pharmaceuticals, it makes sense for you to spend the money necessary to get the patent protection. You know, in pharma, there's so many combinations of molecules that will have the curative effect of the drug that you just came up with. So it makes sense for you to have that kind of protection, and you can get the injunction because you're fighting against your competitor. So it makes total business sense from that space to continue to spend the budget necessary to get the patent protection and knock out any competitors trying to get into your space. Whereas on the IT space, I think things gets a lot murkier. The famous, I don't know whether it's true or not, but Google supposedly commissioned somebody to study how many patents cover a single smartphone. The answer is 250,000 patents. And it's just like kind of hard to figure out at that point what is the value of a patent. When the value of patent is that I can stop my competitor to come into my space and start making drugs that gives me billions of dollars, then yeah, there's a certainty as to value of patent. Whereas your patent is one of 250,000, it's kind of hard to figure out what the value of that patent is. And in the IT world, this is sort of my pet theory, is that we really haven't figured out the value of patents, and we only start doing so after eBay decision in 2005, because I dare say that up to that point, whatever the money you pay to sell a patent lawsuit was a reflection of the power of injunction or the pain that injunction can inflict on your business, because they could shut down your product line. After 2005, that threat has dissipated, and then I think that's the time that when the industry really get into, or the courts and lawyers started trying to figure out what a value of patent is in the IT space. So, there's uncertainty there, but then there's a practical aspect to it, because oftentimes patent budget in a company, it's not really it doesn't really depend on what's happening in courts. Changing case law in the patent area doesn't really have that much impact on your patent budget. It's a reflection of how companies doing at that particular moment. Usually it's a CFO who makes the decision. So, it's like, if you look at one company's patent budget, it's going up or going down. It's not really a reflection of what's happening in the case law. It's more has to do with that company's outlook for the future.
Well, so let's follow up on that, because one of the interesting phenomena I think that we see that does distinguish an industry like pharmaceuticals from software, you see an enormous amount of patenting in the software and the IT industries, the 250,000 patents example. But the most innovative companies, and companies that are filing a large number of patents, right, are usually not plaintiffs in a lot of patent cases, right? What is it that you're buying? Why are we patenting if we're not thinking, hey, we're going to go sue our competitor and keep the generic or the knockoff copy out of the marketplace?
Well, the nuclear missile analogy gets a little tired, but I think it is deterrence to a great extent. As I think your paper points out, it's generally not perceived that it's a great idea for your business plan to be, let's just go copy somebody and not develop anything else on our own. And I think the large number of patents filed by companies does create a deterrence. Certainly for smaller companies, it creates a deterrence for a large company just to knock them off. and creates an incentive for the large company to instead buy them. And, having heard the point in the conversation get many times to, well, if you don't like our price, we'll just do it. We won't buy you, we'll just do it. And having the answer is, well, you're going to have a problem if you try to do that, is a pretty important thing for a company being acquired to be able to say.
Okay, so, all right, so I got at least a couple of possible stories there, right? One is deterrence in the mutually assured destruction sense, right? You've got 500 patents on this technology. I better have 500 patents on this technology too. But then there's also the second piece I heard you say, right, which seems more specifically targeted at deterrence of copying, right? That the advantage of my having this patent is I'm gonna prevent people not from entering the market at all necessarily, but kind of taking from me rather than buying.
Where I see it mostly is in the knock us off versus buy us scenario, which is pretty important, at least in software, because a startup can't, if Microsoft or Google decides to overwhelm them in the market, they're going to be overwhelmed in the market.
Right. All right. So why are the larger companies filing so many patents? Right. I understand why you need some. You need enough to sort of.
I'd modify your question. Also, I'd add to your question: why are they buying patents? I was, and maybe I'm not the best person to answer because I can't explain why the amount of money was paid for the Nortel patent portfolio that was paid for it, or the amount of money that was paid for the Motorola patents, the Motorola mobility patents. I think that. The only explanation I have is deterrence, but I think that you look at what they're buying patents for still after these changes, and the investment to actually file patents is actually much smaller.
So Ken, why does Samsung patent?
Well, I mean, rightfully or wrongly, there is a perception that the patent equates innovation. And when you're an innovative company and you come up with a lot of products, you do want to have patents around your products, and it's very contextual. If you just look at a macro level, then maybe maybe all these changes might have weakened the patent protection. But when you look at specific industry, specific products, the fact that you have patent on some key feature can be the competitive advantage that you have with respect to that products. And that's also true with a small company like startups, for instance. VCs used to not care whether you have patents or not, but that's a long time ago. Nowadays, if you're a startup company and if you have a technology, then VCs expect you to have a patent. And that's also true if you want to go IPO. Then the investment banks want to know what your patent protection is. So that has sort of became a so-called social norm that you mentioned in your article. That it is that for one reason or another, it's companies do need to have a patent protection.
So that's interesting because a lot of what I'm hearing here then is about signaling, right? We're signaling that we're innovative. We're signaling kind of what it is that distinguishes us from the marketplace, and not so much about enforcement necessarily, or at least not enforcement in court, right? Maybe the signaling has kind of got its own deterrence value.
Yeah.
I think if you look, sort of historically, example of a company that sprung up very quickly and competed with companies that had a lot of patents in Cisco. Well, what happened is they sort of got going was that it became very clear if they were going to, if they didn't innovate and patent, then the problem with IBM's portfolio and Lucent's portfolio and all the portfolios out there was going to very quickly become intractable for them. So I think that's an example where the system really worked, that, that company, they were pushed to innovate, to pay their engineers to innovate, and to make sure that they dealt themselves a hand as well.
And so then I think there becomes an interesting question of what happens to those patents kind of as companies age and their life cycles change, right? So a number of companies in the technology industry who do a lot of patenting but are never patent plaintiffs and sometimes will affirmatively say, we don't actually ever want to sue anybody. No, those patents start to look attractive as assets if the business is turning down, right? And so maybe now we start to change our mind about whether we want to file a lawsuit, or maybe we sell them to somebody who could make some money on our behalf. And so I think we're seeing, you're sort of feeding the patent assertion entity machine in a sense.
Company scruples about who they'll sell to have certainly sort of deteriorated somewhat.
Let's say they're not always consistent. You know, it's at that level of transferring ownership or asserting that we get down to the lower level, the detail level, the everyday level of how have these changes that we've witnessed impacted the value of the asset that is sitting on the table in front of us. And, you know, again, this is anecdotal, but I can tell you, you know, in the time since I've come back and participated in discussions about potential filing of litigation, these issues are very much at the fore. I mean, you're looking at people who are about to make a $5 to $10 million investment in an enterprise known as patent litigation, or they're selling something. And they have to do a really detailed level analysis of the risks and benefits. And into the risk pile go all the things that we've been talking about here. And they come up all the time. And it either reduces the price or it reduces the enthusiasm for undertaking litigation. So it's there.
Okay. Is that bad?
No, not in the abstract. Again, here I'm using that word again. Yeah, out of context, the idea of doing really sensible risk analysis is perfectly fine. You know, that's what they should be doing. But all I'm saying is that some of the factors that go into that reflect directly changes that have been made in the patent law that, had these decisions been taken 5 or particularly 10 years before, may have been totally different. So today, you will find people deciding not to litigate on patents that a few years ago they may well have said that, yeah, it was worth it under the analysis.
So, and that, I think the question is of whether that's a bad thing seems to me bound up with the question of whether it ends up reflecting in innovation and research and development funding decisions, right? So I with the apologies to patent litigators in the room, of whom I am one, right? Almost all of the world would be a better place if we had less patent litigation and the same amount of innovation, notwithstanding less patent litigation. It wouldn't be great for those of us who make our money from patent litigation, but everybody else in the world would be better off. So the question, I think, really, the important question is, if I'm making a decision not to file a lawsuit, does that end up feeding back into to somehow reducing innovation, or maybe it has no effect. Maybe it has the opposite effect. That is, I'm not spending a bunch of money, and I'm not causing the defendant to spend a bunch of money on lawsuits instead of innovation.
Well, I challenge you to find out the precise answer to that, Mark. I don't think that we can know the answer, and I agree with you. It would be a perfect world if we had maximum encouragement for innovation and had no lawsuits at all. That would be great.
I think you can make an argument that it has improved matters, because I think that, one example I would cite that I'm surprised that, given the amount of effort that was put into it, that I haven't heard more about is, for example, the Walker Digital portfolio. That was a huge number of patents, many of them business methods, many of them invented by patent attorneys. And it was just this huge mass of radioactive material that was going to go on the market. And I think the reforms, if you want to put a concrete example, if you'd have asked anybody 10 years ago, how much litigation is that operation going to result in, and how much has it resulted in, I think the reforms, especially the eBay case, which Ken cited, which I think is very important. I think that's evidence that's made a huge difference.
Yeah. I agree completely with that, and don't take me wrong. I don't think all of these changes have been a problem. They have helped adjust the system into a place where there is not so much asymmetry of power as there was before, and so you get decision making that's rationally based on the contribution of the technology, at least roughly speaking, better than it did before. But many of the other changes, all I'm saying is, for good or ill, they are being accounted for when people are making decisions about whether or not to sue or sell.
Yeah, I
But
mean, yeah.
Go ahead.
Yeah, so like, one point about, these changes that, some are very practical at some level because I don't know how many of you guys read the FTC report yesterday, but the recommendation they make to the Congress is that in a typical patent litigation, there is involving patent assertion entity and a operating company is that there's asymmetry of discovery burden, which gets exploited quite a bit to the advantage of the patent owners. And things like the 101, what it does is that it does provide a more cost-efficient way of resolving that dispute early on without piling on the cost of discovery. I mean, this helps the patent litigators, and this definitely helps the patent assertion entities. But does it really help society in general? I mean, like you can have 100-day proceedings even in the ITC these days, where you can bring the one-on-one motion during 100 days, and if ITC agrees that patent should not have been granted in the first place, that kills that investigation. And as you know, ITC is a lot more expensive than district court litigation, whereas it's about the same, but you just have to pay it in a compressed time period. So that's why it has a reputation of being more expensive. But things like that really helps. That when there's an efficient way to resolve. I mean, I'm not saying that patent assertion entities do not have a legitimate case. They might very well have that. But to the extent defendant believes that patent should not have been granted on one-on-one ground, let's just hash that out.
So one of the things you mentioned, the FTC's report on patent assertion entities, and one of the interesting things about that report, it's not comprehensive. It focuses on sort of 22 different patent assertion entities, but they include some pretty prominent ones you've heard of. And one of the things they conclude is that the patent assertion entity world is really divided into two different, very different business models. There's the aggregator or the portfolio business model, and those companies are licensing large portfolios of patents. And there's the sort of litigation assertion business model, what Doug Melamed and I called, not so pejoratively, the bottom feeder troll business model. And what's notable about the FTC report is that the portfolio business model seems to actually make quite a bit of money, and the litigation business model seems to make surprisingly little. So one of the things they found was that the vast majority of the money was made in the portfolio business model, even though the number of licenses was actually pretty small. And that by contrast, the litigation PAEs were filing lots of lawsuits, sending lots of demand letters, but they weren't actually making all that much money, and that the vast majority of the lawsuits they filed ended up being settled for less than $300,000. Is that, and I guess I want to sort of kind of try to bring that into the discussion here. Is that something that we think has changed? Is it something that is a result of the changes in the law? Or is the price coming down for litigation assertion for resolving these PAE lawsuits?
I think it has. I think you look at stock prices for some entities like Acacia, and their business has changed. It's gotten harder, and I think that you can make the argument that that's a good thing, and it hasn't cost the incentive on the other end, because I frankly have never dealt with a startup or a VC that one of the concerns when they're funding a company is, well, if this doesn't work out, we don't get the market, You know, are we going to be able to
At least
sell-
we can be a troll.
Yeah,
Right.
yeah, it just doesn't, it's not a consideration. And I think if you cut that sort of tail off of the value, you can kind of almost get it for free in terms of not losing the incentive. So I think you can argue it's only a good thing. I sort of go with the history of, at one time, people didn't appreciate that they could assert these broad patents. And there was a book written in I think the 90s, it was kind of famous, Rembrandt's in the Attic. You know, that, wow, you've got these patents, you could be asserting them, why don't you do it? That was sort of unfortunate because society was getting those patents for free, and then the law profession sort of made it not free anymore. And in addition to the Rembrandts in the Attic, there were a lot of Velvet Elvises in the basement that people asserted. And you know, it just was only a cost. I don't think it really improved the incentive at all.
Yeah, I agree with what Lee has said. It's the issue is trying to identify what that business model looks like and figuring out a way to discourage it or make it more expensive without having any unintended effects on the rest of the system. That is, I think we have seen, harder to do than it is to imagine.
Right, and it's because we're not very good at understanding the relationship between patent litigation and patents and innovation altogether, and because it's very difficult and it's industry specific, surprising things can happen, right? One of which is we make what looks like big changes to us and they don't seem to have a very significant effect. I'll talk a little bit more about that in a minute in some interesting ways. But you could also imagine the reverse, right? That suddenly the complex system kind of starts to spiral into a new equilibrium because of a change that didn't look all that significant to us at the time.
Yeah, it's probably a nonlinear system, and you can dial back the probability and hurt the trolls to some extent, but then you use too blunt an instrument like 101, and all of a sudden, you know, you get the Sequinom case. And I think that there is a danger that we've been changing the system a lot, and the changes take a while to play out because different courts apply them different ways. You know, the patent trolls to some extent are heading to the high ground, which ironically is in East Texas. And I think that is one effect that when that high ground disappears, if it disappears, venue reform might have a very nonlinear effect in terms of causing all the other things that have been done all of a sudden take effect.
Yeah, I have to agree with that. I was thinking that what kind of patents would these portfolio patent assertion entities might have, and I think there can be like two kinds. One is like intellectual ventures that aggregated a lot of patents, and I think the play there is that the sheer number of patents is just overwhelming to any potential defendants, you know, and I guess to a certain extent that's what IBM and AT&T did, is that out of our 30,000 or 40,000 patents, I'm sure we can find one patent that will read on your products, and you know, most companies ended up just cutting a deal with IBM and AT&T, and I think intellectual ventures sort of you know, cashing in on the idea. That's one type of portfolio patent assertion entities. And I think the second type might be the ones who have a lot of standard essential patents, SEPs. And you know, I think the SEP is the area where, you know, what Lee just mentioned could actually be happening, because I think the, you know, SEPs used to be thought of as very valuable because of industry, you know, that particular industry that has a lot of products that are compliant with certain standards are basically stuck. So you know, if somebody has a portfolio of SEPs, then obviously that portfolio is going to be, you know, you can use it as a leverage to extract a lot of royalties. But you know, things have changed, and competition authorities are looking into SEPs, and because of court decisions and then scrutiny by competition authorities, I think the SEPs have certainly lost values. And you know, I think over time that some of these portfolio patent assertion entities may not be making so much money to the extent they were depending on SEPs for their leverage.
Well, and it's also the case, I mean, I think the analogy to IBM and AT&T is exactly right. If you've got a large enough portfolio that I can say, yeah, look, you might invalidate the first 5 patents I bring to you or even the first 50, but I got an endless parade back behind it. Just pay me for a portfolio license. It's easier. That model has been very lucrative for practicing entities like IBM and for companies like Intellectual Ventures. Though what's interesting is that as Intellectual Ventures has actually started to enter into the litigation world, right, as it's been harder for them to persuade people, I think, to pay large sums without enforcing, they haven't done all that well. I mean, the implicit story, right, is I've got 30,000 patents, I'm going to pick the best ones, and darn, these are good patents. But IB's record in court hasn't been so great.
Yeah, I think that's a reflection of, I mean, it just still goes back to the point that you still need to have a good patents in your portfolio. I think when IBM made a threat, people understood that IBM was at the forefront of many of the innovations that other companies ended up using. So when they say, I'm sure we can find at least one patent that reads on products, a lot of people probably have agreed with that statement. Whereas when it comes to Intellectual Ventures, I think they're businessmen, so they wanted to reduce the cost of aggregating all these patents. So I don't think the patents they had purchased for themselves were necessarily of the high quality, throughout. So when it comes time to pick a particular set of patents that will read on a particular defendant company, they may end up getting a not so good quality patents. And maybe that's the reflection of or their courtroom results may be simply a reflection of that fact.
Jim, are companies looking outside the patent system for alternative means of protecting innovation?
Yes, funny you should say that.
It's almost like we rehearsed that question.
Yeah. One of the things I had to do when I headed the PCT was to go around and talk to our customers about how pleased or not they were with the service that we were giving them. And what I found was, as I talked to many of these large multinationals, was that they were very happy with the patent system. The international patent system was working very well for them. It was predictable, and they really didn't have any complaints. But a number of them talked to me about the anxieties that they did have, which was about the information that they weren't patenting, information which had all of a sudden during their executive lifetimes become fabulously more valuable than it ever had before. They had sort of entered into an era where they were riding entirely the value of their data, and the data were extremely vulnerable because of the digitization and globalization of commerce. And so, and as if that wasn't hard enough, they had the added management burden of figuring out how to exploit all of this data because they knew that they couldn't go it alone and they had to engage in collaborations, and how do you do that all around the world, et cetera. So, this interest in trade secrets is something that's been building for quite a while, and even during the time that I was in Geneva, the EU was heavily discussing and working on adopting the Trade Secrets Directive because industry had told them that they needed better enforcement of these rights in the continent. And so anyway, then of course when I got back here and the DTSA was introduced into Congress, it was very clear that there was a broad collection of companies that had come together in agreement on this issue and saw secrecy as not just something that they needed fixed in order to have a better enforcement mechanism, but something that they were thinking about more in asset management terms. That's what I have seen over the last few years. And of course, in the context of the AIA, which created IPRs, we have a lot of concern raised in many quarters about what this has done to the value of patents. The same statute also reduced what I call trade secret anxiety by eliminating, practically speaking, best mode requirement, by eliminating, sorry, Mark, most people think it's been eliminated, the forfeiture doctrine, and extending prior user rights to all technologies. And so what this did is give those who were considering at the front end the decision whether to hold something as a trade secret a new sense of confidence that they could do it without taking a huge amount of risk, at least not the level of risk that they had in the past. So those are the conversations that are going on now, and I've had some chief patent counsels tell me that they are actually having these conversations at their front-end meetings. You're seeing this too?
Absolutely, yeah.
Lee? Yeah.
Is that good, bad, indifferent?
I think it's just fine.
Okay.
I mean, look, I know there are people, including Judge Moore in her dissent in the Tangri case, who think that, encouraging trade secrecy is essentially a bad thing because it interferes with the objective of the patent laws to achieve public disclosure of innovations. And the problem with that sentence is that wasn't one of the objectives of the patent law. The patent law demands disclosure of innovation in order, as part of the bargain, to provide the limited monopoly right. But it's not by itself the thing that we want to do, right? We recognized, and the Supreme Court described this to us way back in 1974 with the Kawani oil case, that trade secrecy can sit right alongside patent law very comfortably because without, all you need to do is think about what it would be like without it. And businesses would hoard their information. They would hire fewer employees. They wouldn't engage in collaborations. And so you begin to understand that what may sound paradoxical is an absolute fundamental truth about trade secrets. They encourage and enable dissemination of information commercially, and in many cases in a very efficient way. So, yeah, I think it's a good thing that people are paying attention. The surveys that have been done in recent years have indicated people have been actually using secrecy more and more for quite some time.
I mean, it's really come down to whether you can keep your secret, because if it's easy to reverse engineer, then you're much better off disclose it and getting patent protection. So, yeah, I absolutely agree that trade secret law can reside comfortably right next to a patent because it gives different tools, or maybe whenever business has a innovation, it has to choose. Would you want to protect it as a trade secret or as a patent? And the big part of it is that can you keep it as secret? Or it's easy to copy, then forget it. I'll get a patent protection.
Or maybe disclose it and not patent it. So we do see in the software world a kind of sizable community that takes either an open source route or simply a kind of open innovation route. Yeah. So that's very interesting phenomenon because like 10 years ago when I was doing a lot of transactional work, when I buy some company for my client, I could I could insist that the seller rep and warrant to me that those software that they're selling to us does not have any open source because I want to make sure that my client's software doesn't get contaminated by open source license coming from this seller software, and that was not atypical. Whereas if I try to do that now, I'll get laughed out of the deal room.
You would not do many deals.
Exactly. They'll say, So I think the open source is out there, but what's really interesting is that the companies that used to pride themselves and were probably those companies that insist on reps and warranty that there is no open source in the software I'm buying from you. are the one who are using open source software quite often, and in many of their applications. Microsoft, Qualcomm, Intel's of this world actually are embracing open source software to a point where that I think the industry has decided that next telecom standard, 5G, is going to be implemented in software and mostly through open source projects. So you probably want to think about the long-term effect of such collaboration or open source projects on the value of your patent portfolio, because most popular open source license nowadays is Apache 2.0 that comes with a patent grant. Granted, you only give patent license with respect to your own contribution, but if open source project becomes de facto standard or becomes the preferred embodiment of the 5G standards and everyone's using it, and you're one of the 100 contributors to that code, how are you going to separate out what your contribution was and what is exactly what patent rights actually have been passed through your contribution? Sometimes it might be very difficult to tell. So companies are in sort of like, I guess you can always say, I'm not going to participate in open source project. I'm just going to wait, and then I'll just take the code and use it. But the problem is that if you do that, you lose control over where the code is going to go, and you may not support the features that you want in your products. So if you have to participate, then you really need to think through that. What is that I'm giving up? Is that really worth giving up my patent rights in return for the benefit I'm going to get from participating in these open source projects?
Right, and it's not just the patent right issue, isn't it? It's management overhead.
That's true,
for
too.
watching over what parts of the code were affected by all this.
And and the thing is that when these open source project is in full swing, sometimes it's really hard to tell who is contributing to whom. Oftentimes, it's not the companies, but it's the individual engineers. So is this guy, has he worked for me, or has he worked for my competitor, or has he switched out? Well, he probably worked for several companies,
Right.
So where was he at this time frame when he contributed this much code? And you have to do that maybe 10 years down the road. It gets quite messy at some point.
Right, anything else? All right, so one of the last things we wanted to do before we open for questions is to show you guys some data. So lest you think that the patent system is headed for imminent collapse, I think there's at least some reason to think that it's hanging on a little better than people have thought. So background, obviously, the last 40 years have seen some pretty dramatic changes in the substance and procedure of patent law, and I think you can largely put those kind of epochs into a couple. We start in 1982 with the creation of the Federal Circuit, and a pretty solid strengthening and expansion of patent rights for about the next 2 decades, right? From 1982 until probably about 2005, patent rights are getting stronger along virtually every dimension in fairly significant ways. At some point around 2006, that starts to change. The eBay case is a bellwether, but there are a bunch of others, Seagate involving willfulness of various other things, and the rise of IPRs in 2011, Alice in 2014, and so forth. So I think you can look at the patent system and say, well, you know what? We've had pendulum swings since at least the 1600s. Maybe what we've seen here are some pendulum swings, right? We had weak protection in the 70s. We got really strong patent protection over the next 20 years, and now we've moved back over the last 10 years. What's interesting is that the data on the kind of fundamental characteristics of the patent system don't seem to map neatly to the strengthening or weakening of the law. So let me just show you a little bit of the data. So this is, take a look at the blue lines on the top, right? These are your patent applications filed going back to 1999. And, we see a pretty steady climb. It's not an absolute straight line. There's a period, you may recall, the Great Recession of 2007 to 2009. That shows up in the patent data, not as even a drop in the number of applications filed, but as a sort of leveling off in the number of applications filed every year. But then we continue on our merry way. Now this chart ends in 2014, but the numbers still continue to grow. So this includes 2015 and projected 2016 data. And, you know, we're leveling a bit. The climb is not as great as it was, but it's still going up. So even in a world in which I think in particular industries and business methods, it's not such a great time to be filing patent applications. In medical diagnostics, maybe not, although it was interesting to hear Kathy Koo say, yeah, we're still filing in biotech because we're still actually getting good deals in that area. We're seeing overall across the patent system as a whole growth in patent applications and that also turns out to be true in patent grants. And in fact, what's interesting about this chart is you do see, starting in the 1980s, a pretty solid climb in the number of patent grants. You see it level off actually at about the time patent law was at its strongest, right? So starting in about 2000, we level off for a period of 8 or 9 years, and then we take off again, and the number of patent grants is now almost double what it was 10 years ago, and that's true even as the substantive law is theoretically making it harder and harder to get patent grants.
So I think you're seeing in this graph some of the patent office getting further and further behind with its backlog and then chewing through its backlog.
So I think that's right, and I think it's all what you also see, and these are related. You can map it quite nicely to presidential administrations.
Oh,
right?
Yeah.
You got a big ramp up at the end of the Clinton administration. You go completely flat through the entire George W. Bush administration, and as soon as Obama comes in, it takes off again.
You could characterize that as which party and also whether the head of the patent office is a patent lawyer or an IP lawyer.
I think that's right, but I also think it relates to Lee's. I think it relates to Lee's point about backlog in an interesting way, right? Because since we have constructed the patent system so that I get an unlimited number of do-overs, right? I can come back and file a continuation application, and since we've kind of normally played the game where I say I want a patent, you tell me no, I make some change, maybe you tell me no again, I make some other change, and eventually you tell me yes. I think one of the things that happened in the George W. Bush administration was the patent office started saying no because they were under directions to say no more often, and people didn't believe them. Right? So rather than go away, a lot of the applicants just kept filing continuation applications. More applications, the backlog grew because we're still trying to process all of these things.
Yeah.
And then in the Obama administration, that starts to change.
Yeah.
Could it is it possible that the patent budget is simply a percentage of R&D budget for any company? And I don't know. I mean, it would be interesting whether a certain administration offer R&D credit. Maybe that's responsible for a spike, and maybe under certain administrations that went away. That's why it finally went down. I don't know.
It's a good question. I'll show you some data in a bit. I mean, that was a kind of logical explanation for me too, but that also doesn't seem to map to any of this, which really kind of surprised me. So here's lawsuits. This goes through 2012. The spike in lawsuits at the very end, of course, is in part an accounting question as we pass the AIA and we change the way in which we account for a number of lawsuits. But here you see, again, you see a kind of growth in the period in the 1990s, but you see a leveling off in the number of lawsuits at the very time that the patent system is seemingly at its height in the early 2000s. And then you see an increase. Now, as we said, some of that increase may be a function of the way we count. So a better way to count might be to look at number of suits per patent in force. That seems to be kind of all over the map. The blue line here is patents in force. We do see a kind of a spike in the number of suits per patent in force in the 90s. Drop actually in the early starts in the early 2000s and goes into the late 2000s, goes up again after the AIA. What we really ought to care about, though, are the number of defendants, right? Because that's going to smooth out the AIA thing. And these are defendants in non-practicing entity suits. One of the things that's most remarkable about this to me is that the NPE suits start to really take off kind of at about the time that the patent law starts to weaken in ways that, that seem to make it less desirable to file a patent lawsuit.
So I wanted to just note on sort of patent lawsuits, to some extent you're measuring uncertainty because things don't settle when the law changes and becomes uncertain. Even if it changes for the, to disadvantage plaintiffs, you still end up with more fights because people, I skipped the 5th grade when I was in school, and in 6th grade I got in all these fights because I hadn't figured out that I was not the biggest kid in the class anymore. And I think you probably see a little bit of that in terms of the increased number of suits.
Yeah, I think that's right. And there's definitely selection effects here. And one of the things we'd like to know that actually turns out to be really hard to know because as a statistical matter, because of confidentiality is, right, were there a bunch of NPE assertions, demand letters, right, during the kind of stronger period that people just pay, that they now then take to litigation instead, and if so, that could be an indication. Although, and I think the answer to that may well be yes, right? Though, if one is a patent litigator, right, one might look at this and say, oh, well, okay, you know what? Actually, that's good for our business model, right? It's not the case that weakening patent rights means less patent litigation, right? In fact, it might mean that weakening patent rights, at least to some level, means more patent litigation.
But when I made enough trips to the nurse's office in 6th grade, I eventually stopped getting in fights.
So that's right. And so what that says, I think, is there's certainly a level of weakness of the patent system beyond which nobody's going to bother to enforce at all, right? But there may well be, there is, right, substantial room to file litigation, and people will do it even as we've sort of weakened patent rights in the way we've done so in the last 10 or 12
I think it would be interesting if you can sort of look at the how economy was doing at that particular point,
all right,
because
I'm going to do those things. So let me just skip through. So the notable thing about damages is damages seems to be a random walk. It's so driven by a few large verdicts in any given year. It's hard to come up with any real numbers. This is just to sort of show the quarterly filings in case you thought, well, you know what, we drove off the cliff after Alice and nobody's filing lawsuits anymore. It's not true. It's actually gone down a little bit from its height in 2014, height in 2015. Down a little bit this year, but it's not down, frankly, all that much. Every quarter that the numbers drop, people say, oh my God, that's it, we're done, and then the next quarter they shoot right back up. We've also got data a little bit on the brokered patent market. This is much harder to get useful information about because most of it is secretive. So this is a particular set of brokered patent data that comes from auctions. And again, doesn't really, it's certainly leveling off, but it doesn't seem to be falling off of a cliff. This is actually, to me, the most interesting, and it goes a little bit to the selection effects issue that Lee identified. The litigation win rates, both on validity and overall, are essentially unchanged over a kind of 20 or 30-year period. Patentees win validity when it goes to judgment somewhat over 50% of the time, but less than 60% of the time. That's been tight within a narrow range from 1982 to 2014. They win overall about a quarter of the time, right? So they got to win validity and infringement, and they win each of them about half of the time, and so they win overall about a quarter of the time. Yeah. And that's so essentially.
But doesn't it just mean they take whatever the current facts are into account when they make their decisions?
So put that fact in combination with the number of lawsuits, and we see something very interesting, right? Which is the move on the one hand in the 80s, 90s, 2000s to strengthen the patent system, and on the other hand to kind of to cut back in the last decade, right? Didn't move the outcomes. And it didn't seem to change dramatically the number of lawsuits filed. It may well mean that we're filing different lawsuits than we were, right? That as we strengthened the patent system, we were filing suits on weaker patents because we thought we could get away with it. And as we weakened the system, we're filing suit on stronger patents. But it doesn't seem to be changing kind of the fact that patent litigation is happening at a rate that's not driven by the substantive outcome, even if it's changing which suits are being filed.
Wow.
Mark,
I don't know about that last part, not being driven by the substantive outcome, because I mean, that's what they do at the, throughout the entire case. They keep reassessing.
Yeah, although, so this is why this is, to me, is a really interesting and surprising finding, right? But
is this jury verdicts?
No,
or
this is all rulings, it's
so
all substantive
summary
rulings.
judgment.
Summary judgment, motion to dismiss, jury verdict, the whole bit.
Uh-huh.
And I think one issue, Jim, is that it may be that a lot of the reasons people file patent lawsuits don't actually have a lot to do with winning on the merits, right? Of course, most patent cases settle, right? A whole class of people, the litigation PAEs, aren't interested in the, if I'm going to settle for less than $300,000, it's not because I'm interested in winning my case on the merits at the end of the day. But I think that's also true of big companies for whom they can use a kind of bullying strategy, right? If I can derail a smaller startup competitor by filing the lawsuit, interfere with their IPO. If I'm a pharmaceutical company and I can get the benefit of an automatic 30-month stay merely by filing a lawsuit, there may be incentives or reasons for me to file lawsuits that actually aren't because I hope to win at the end of the day, and that those may drive a surprising number of the cases. So I want to look at one possibility that Ken mentioned, right, which is, well, isn't this just part of the broader economy, right? So here's economic growth in 2009 constant dollars going back to 1960. Overall, in the last kind of 55 years, we've got economic growth at about 3.4% a year. It tweaked downwards with the Great Recession, and it hasn't fully recovered, but it's still got economic growth at about 2.3% per year. This is growth in patenting. Doesn't look much like kind of we're just following the overall economy along. We see a major kink around the creation of the Federal Circuit in 1982, and it kinks up to about 4.4% a year. So patenting growth substantially exceeds growth in the economy as a whole. Now maybe, of course, as Ken says, it's not a growth in the economy as a whole we care about. It's R&D growth that we ought to care about. That's what should drive it. But it turns out that R&D growth is not an explanation either, that the R&D growth as a percentage of GDP has actually stayed largely flat since 1960. Well, actually, flat is wrong. It's fluctuated, but it has not changed substantially. It is true that more of that is private, is private rather than federally government funded, although federal government funding also ends up patenting as well. And the other interesting thing to note, and this is from Colleen Chen's data, is how much expenditure in R&D per patent we've got. And what's notable about this is, in the chemistry industry, it definitely see a fluctuation. You see a drop and then an increase, but it's roughly the same now as it was back in 1984. Well, this only goes through about 2008, but roughly the same in 2008 as it was through back in 1984. You spend about $5 million, $5.5 million per patent you get. Look at electrical equipment and computers, though, right, where it drops from a patent every $5 million in expenditure to a patent every $1 million in expenditure. We've started patenting much more intensively in the IT industries per spend of R&D dollar. Now, maybe that means we're just much more efficient innovators than we used to be, but it might also mean we're much more efficient patenters than we used to be, whether or not we're driving more innovation. So you can draw various kind of conclusions from this, and you might like or dislike those conclusions. Maybe the changes that to all of us as
Mark, any idea what that graph does after 2004? It's very interesting.
I don't, unfortunately, because it's not my data.
Before 2004 is really a sea change of stuff that was thought to not be patentable now becoming patentable. So I think you're seeing
that could be right.
very very clearly. I'd be fascinated to see what happens after 2000.
Yeah, no, it'd be very interesting to see that. But I think you're seeing other things too, right? That is, I think you're seeing the growth of the open source movement. You're seeing the growth of software invention, R&D money pumped into software. Yeah.
You might see the pendulum swinging back up in that
I think
graph.
it's
That
entirely
would be fascinating to know. So
Yeah, absolutely. So, I don't have a great explanation for this, right? I think one possible explanation is the changes that we're making affect us a lot, and they look huge to us, but they actually kind of look not so huge as you step further back, and that the pendulum swings are not quite as wide as we think they are living within the scope of the pendulum. Might be right, might not be right. May be the case that there are things driving both the decision to patent and the decision to litigate that aren't actually driven by the substantive merits, right? That I'm patenting because I want to show that I'm innovative, or to signal to my venture capitalist, or because other innovative companies do it, and those motivations, at least within a range of changes in the law, aren't really changing, right? That I'm still going to have those motivations to file patents. Maybe I still have the motivations to file lawsuits for reasons unrelated to do I want to win the case at the end of the day. And I mean, I think you can also kind of disagree on whether you think this is a good thing or a bad thing. And the good news is, I think both of those of us who warned in the early 2000s that we're going to mess up innovation because we're strengthening the patent system too much, and the people who are concerned that we're going to mess up innovation by weakening the patent system too much today, we might both be wrong, right? That is, there might just be a lot more resilience in the patent system than we think there is. But it may also be the case that the relationship between the patent system and what we're hoping to do, which is drive innovation, is a lot less obvious than we think it is, right? That the reason people are patenting, the reason people are filing lawsuits might not have so much to do with driving and promoting innovation, in which case we kind of ask the question, well, what are we doing here?
So, Mark, I think one issue is that this is like macroeconomic picture.
Yep.
Whereas our everyday life is sometimes measured at the microeconomic level, quarter to quarter. I think that's so maybe this is what's happening at the macro level, but we definitely feel that when things change, it actually, those changes actually impact our lives quarter to quarter. So.
Oh, absolutely. No, and I think, I mean, a couple things to note about that, right? One is that I do think there may very well be sector-specific differences in this, right? And a lot of the smoothing effect might be, right, that, you know what, if you're in the mechanical arts, if you're in the pharmaceutical arts, if you're in the automotive business, Alice doesn't really much affect your life. And it's not going to change the way in which you behave. But I also think it may be the case that, you know what, even if people are filing patent lawsuits at the same rate or an accelerated rate, even if they're filing patent applications at the same rate or an accelerated rate, it's still, these legal rules affect the way we behave. So if invalidation of a patent now costs $300,000 in the PTAB instead of $3.5 million in the court, well, that's a lot of money that isn't spent on patent litigator legal fees, right? And that means that patent litigators are chasing a bunch more cases, and we're not going to support the same ecosystem of patent litigators. Yep. I mean, it's interesting to me on prosecution because what Lee said at the beginning might seem to point the other direction, right? That is, maybe we ought to be spending more money on prosecution in the IT industries because it's actually important to get the patent right than it felt like it was 15 years ago.
Yeah, maybe you need to do it better rather than hoping to fix it on the back end with a silver-tongued litigator.
Right.
Which I think that...
Sounds like you've said this before.
No, I think one thing I would like to consider is where you say resiliency, I tend to think latency. And I'll tell you, as an engineer, if there was one engineering course I would like to get lawyers to take, it's control theory. Because the hardest thing to make a system hardest to control is latency. So when I was at a summer job one of the things, we had this tank that get material discharged into it from the train in the middle of the night. Some of it would be congealed, but the point is we had to get it to a certain temperature so it could be discharged a couple days later. The huge problem with that was that the heater was in the bottom of the tank and the sensor was in the top of the tank. So, you'd have the operator turn up the heater and nothing happened, turn it up some more, nothing happened, then all of a sudden, they fried the stuff at the bottom and the thing would go out of control, get way too hot. And trying to control a system like that is hard, and there's a lot of reasons there are latency in the patent system. There's a lot of, and Mark pointed out, I think, very good, that people, one of the first things that happens is when their business gets harder, people try harder. I think you definitely see that in the patent market, people trying to sell harder. And it can absorb a lot of control input, and then all of a sudden it sort of breaks and runs out of control. And there is the possibility, as just like if you just kept heating up the tank and thinking nothing's happening, and then all of a sudden, oh my goodness, here come our effects. I think there's a good chance that can happen, and it has to be considered.
Oh, absolutely, and that's why to me it's important to take the long view, right? And I hear Ken that says, you know what, in my business, right, what I have to do is report at the end of the day on the quarter, right? Did we generate money? Did we lose money? How much did it cost, right? But from a kind of macroeconomic perspective, what we want to try to look at is, you know what, do we actually see results kind of, and you wouldn't expect to see them this year or right away, right? But do we see them with some latency? And one of the interesting things to me about the kind of long-term data going back into the 70s and the 80s is we don't see any obvious connection between substantive patent law changes we made 25 years ago and kind of the moves we might have expected to result from those in the system. Doesn't mean they're not there, but it may mean they're attenuated as well as latent, or that there's an equilibrating tendency in the system. Yeah, right, or that the system equilibrates in ways that Jim has mentioned earlier. All right, why don't we open it up for questions? And there should be a microphone floating around. Microphone coming to you, and please identify yourself. Not a working microphone, but a microphone. All right, I think he's got it now.
It's a gain of 1.
Campbell Yord, thanks very much for the presentation. First, a comment. I was listening to David Burton, the founder and partner of Global IP Law Group. They led the Nortel representation on that case.
Can you speak up a bit? Or
Put the microphone right in front of your mouth.
So I was listening to David Burton, who was lead representation in the Nortel $4.5 billion patent auction, talk to Franklin Germain, a managing director at Goldman Sachs, about patent valuation and the market for lending on essentially secured patents. He postulated that while valuations in the U.S. were down, mostly because of post-grant proceedings, fee shifting, 101 jurisprudence, I mean, you name it, all those essentially things that are making patent enforcement in the United States harder. So that valuations on U.S. patents were down, but valuations of international patents, most specifically German patents, were on the rise because of some of the easier enforcement, cheaper, faster enforcement mechanisms that they have. Also noted that demand for particularly Chinese patents was on the rise. So with that in mind, and as well as the title of this topic being, what does the future hold? This is kind of a very future-oriented question. I wanted to know what you thought the bigger risk to the business of U.S. patent procurement as we know it. The bigger risk, and I'll give you 2 evils. First evil is fewer U.S. filings due to growing importance of particularly German patents because of the faster and cheaper enforcement mechanisms we talked about. So that's number 1. And then number 2 would be same or more U.S. filings, but fewer attorney hours due to the rise of artificial intelligence and machine learning software to augment or replace attorneys actually doing the drafting. So what is the bigger risk to U.S. patent procurement in the future?
All right. Well, as the co-founder of one of the companies that does artificial intelligence in the patent system, I'm inclined to view that as an opportunity, not a risk. I don't think it's going to come take your job anytime soon. Lex Machina is powerful, but it's not that powerful. I do think the international point is a really important one. And I think it's important for us to think about, again, at the macro level, innovation in global context, right? So if the US patent system weakens and the German and the Chinese patent system strengthen, well, you know what? Overall, for innovation around the world, that might not be a terrible thing, right? It might be a kind of a wash, right? Because it's not the case that only Chinese companies patent in China, only US companies patent in the United States. Quite the contrary, right? The majority of patent applications filed in the United States come from overseas. There's a huge growth in patenting in China, not just by Chinese companies, but by foreign companies. And so if the patent system is driving innovation, it is a combination of the worldwide patent rights you've got that are driving innovation, right? And, you know, we might be better off here in the United States if we've actually got fewer or weaker patent rights in the United States, but US companies are still benefiting from stronger patent rights in China and Germany, and it's Chinese and German consumers who are paying the costs, right? There are injunctions there, but not here. That's not great for patent litigators in the United States or patent prosecutors in the United States, so it's not so great for those of us in this room.
I think you'd be naive not to realize that what is going on is there's just different pendulums that are different states in their swings, and it is true that in Germany there's been a swing towards stronger enforcement, but to rush in like you were buying stock in 1999 in .coms and change all your prosecution to Germany would be a pretty silly thing to do, and so I think that companies, certainly my clients, are filing more often in Germany, sometimes even directly, as opposed to filing in the EPO. That's something that you want to kind of take with a grain of salt, because one thing that do the work of patent law scholars, and that when the pendulum gets too far one direction, it tends to go back. So.
And it doesn't stop in the middle, right? It keeps swinging past the middle.
We have not achieved that, and it's because I think of this latency. It's the nature of the system's hard to control. But I don't see Germany becoming East Texas anytime soon.
Maybe Mannheim.
What?
Maybe Mannheim. Lee, I agree with that. Although I do think that I think there's a decent argument that says China is different. Because I don't think we've had a pendulum, right? We've added a new player to the market in the patent system in a sense, right? Because there hasn't been kind of strong Chinese patent protection and then weak Chinese patent protection. We really see it ramping up, and that doesn't mean it will always continue to ramp up, but we are adding that into the mix.
Yeah, and just because companies are getting patents in Germany and in China doesn't mean they're not getting them in the U.S. I mean, these get stockpiled for future decisions on where to enforce.
I think, we're still, go ahead.
Yeah, I mean, the way I look at it is that, obviously the market size is that China has and Germany has, it is a indication that they can actually have a very strong patent system, because, why people come to the United States to enforce their patents? Well, because injunction in a huge market like the United States has real teeth. Damages award in the United States, because of the size of market is going to be significant. But I think the one issue with China is that the remedy part still need to be worked out, because I think I don't know if it's still true or not, but I was like flabbergasted when I talked to a Chinese patent judge 10 years ago. Okay, so somebody sues their competitor for patent infringement in China, gets a judgment. So how do you enforce it? Does the court enforce it? He looked at me kind of strange, like, why are you coming to me to enforce my order? I gave you the order, then after that, it's up to you to enforce it. It's like, what? So, yeah, that part needs to be worked out, because unless there's a clear path toward enforcing your judgment to a degree that's where you can get either injunction or significant damages, it's going to be a problem. And Germany, yeah, I think you can actually get injunction in Germany relatively quickly, but I think the discovery is not available in Germany, so I think the kind of cases where you can really enforce in Germany are probably SCPs, because you don't need a discovery, to the extent your competitor's product implements certain standards, then you can get infringement case. But value of SCPs is kind of going down, and after that,
products on the marketplace, if I can buy it and reverse engineer it.
but in other type of products, it might be difficult for you to prove the infringement case. So I think that so I understand your concern, and if you're patent litigators, you might really concern about those development. But I'm thinking that we still have quite years to go before we really have to worry about, well, do I need to get European license to practice in Germany or China? So.
I think China, we are still wondering what enforcement's going to be like, but I think you will see an increase in filing, really for the same reason that Japanese companies file so much in the U.S. They file more patents, but they certainly aren't more often plaintiffs. There's concern about keeping the market open, and I think that U.S. companies are going to file more and more in China for that reason.
Makes sense. All right, Stu. Microphone. The microphone's not.
There you go. Thanks. You know, if you put charts up, I'm going to think about it for a while. There's a longer story there, a longer tale that begins 20 years before all that. If we look at Silicon Valley, and part of this could be due to the onset of new technologies. 40 years ago, Silicon Valley was orchards, and land use changed as a result of the types of companies. 40 years ago, we were manufacturing hard disk drives of 8-inch drives, and as there were transitions from a small number of large players like Connor and IBM making 8-inch drives, then there was progress down to smaller drives, then to floppy drives, then to RAM. It expanded the market, and I'd be interested in plotting the technology changes over time with the data you have of the number of patents going on. But I think it was sea changes as the technologies change over time.
Yeah, well, look, I mean, I hope it is, right? I mean, if that's what we want the patent system to be doing. And a part of the problem, of course, is we're aggregating across a lot of different industries, and so we might, at one time, we've got a boom in semiconductors, and at a different time, we've got a boom in biotechnology or aviation or something else, and those all kind of pile together into the patent prosecution numbers. I think that's actually one of the reasons why the system has some equilibrating tendencies in it, right? Is that it's not something that kind of all stands or falls at the same time, and things can happen differently. I also think it's one of the reasons why we probably ought to be happier with the idea that some of these changes are industry specific, that they're targeting particular types of things, right? That we don't have a kind of Alice for all patents. We've got it in some very specific areas. I happen to agree that we've got it in some areas we shouldn't have it, and I'm even sympathetic to the idea that we shouldn't have it at all. But the fact that we don't have Alice for up and coming areas like robotics or material science or things of that nature, I think helps to smooth things out.
Maybe not material science, but I think we're going to have it in robotics.
Maybe. My guess is that all the robotics patents, the court looks at those and they say, "Boy, those sure look technological dots." It doesn't mean people won't argue 101.
I'll tell you, if
that.
I'm the plaintiff and your firm is representing defendants for the motion to dismiss, I'm nervous in robotics.
Other questions?
Hi, I'm Gerben Hartman. Is it working?
Yeah.
Hi. I'm in the LLM, Law Science and Technology here at Stanford. I have a question. I've read your paper and you find this pendulum swing from stronger protection to weaker protection. And when you zoom out, you see that in all the graphs. But I was wondering, if you zoom in on particular changes, whether or not dramatic, like these substantive changes in law, could you find maybe not one pendulum, but a multitude of pendula swinging one way or the other? Because if we're looking at, for example, the four-factor test for injunctive relief in eBay Merck Exchange, you would probably see that most non-practicing entities and then the troll bottom feeders out there, they won't get injunctive relief when they cannot show irreparable harm. So that is definitely an effect that when you zoom in, you see that the patent system is indeed changeable and not super resilient.
I let me say two things, right? One is that I think it's certainly right to say that individual legal changes have consequences, and I think I don't think that's inconsistent with what I'm trying to suggest in this broader story. So there are studies, for instance, that suggest that the move to first to file changes who's likely to file patent applications, right? And it moves it more towards corporations and away from individual inventors. There are studies that have looked at the effect of the shift from the 17-year to the 20-year patent term, and that changes that actually increases the incentive in some industries to file, decreases the incentive in other industries to file. So there are clearly effects of the law. I guess the broader point is twofold. One is that they can tend to wash each other out, in part because the legal effects can be significant. So yes, non-practicing entities are probably not going to get an injunction after eBay. Pharmaceutical companies almost always get an injunction after eBay, and even in the IT industry, practicing entities usually get an injunction after eBay. So the effect is not, well, we've eliminated injunctions, it's narrower than that. And the overall effects are pretty small. So yeah, we changed people's incentives to file patent applications in various ways when we moved from a 17-year to a 20-year term. We didn't actually move the total numbers very much, though, right? It's a statistically significant change, but it's a small statistically significant change. It doesn't result in a kind of fundamental shift in the number of applications being filed.
It's always hard to make the argument it could have been worse, and that that's the problem with the things we did about the financial crisis. Mark showed his graph of economic growth, and the fact that it stayed around 2% could have been a really good thing because it might have gotten a lot worse.
Right.
And I'll tell you, after all the publicity of the RIM case and what NTP did to RIM with the threat of an injunction, plaintiff attorneys and people seeing that and the effect of the follow-on lawsuits, the increase to the system that would have caused, I think it was extremely important that eBay happened, and you can argue that it sort of prevented things from getting a lot worse after that particular episode. I think you can make that argument pretty effectively.
All right, I think it could have been worse is the theme on which we will end. Thank you all for coming, and please join me in thanking the panel.